Today we are talking about the differences between the invention and innovation step within patent application tests. First off, invention is the idea of creating a new product. When we think about inventions, we think the light bulb, the automobile, the aeroplane, and the telephone. When we think about innovation, it becomes a little harder to define. We often think about technology, such as iTunes, iPods, and Facebook. But innovation occurs in every industry. For example, pharmaceutical and medical advancements are often innovations. So let's look at the different thresholds between applying to patent an invention and applying to patent an innovation. Standard application tests relate to inventions. To obtain a standard patent, an invention needs to be inventive or not obvious to another person with similar skills in the same technology as it existed in Australia before the priority date of the claim. In order to determine if something is inventive to meet the threshold, we question, would a non-inventive person who is experienced and knowledgeable in the area of technology to which the invention relates, when faced with the same problem that the invention has solved, have taken as a matter of routine whatever steps there were that led to the invention? The full court in Lockwood's case concerning patenting key control latches developed a 5-step process to determine inventiveness: to identify what stage is inventive, to determine the relevant art with which the invention is concerned, to determine the general common knowledge on the relevant field at priority date, to identify differences between the claimed invention and state of the art, and to determine if differences involved some degree of inventiveness. So then what does not obvious really mean? The High Court in Alpha Pharm's case, which regarded a patent for the formulation of a drug compound which does not become degraded by stomach acid, noted that there is no single test for obviousness and adopted a narrower requirement than steps obvious to try. It was discussed that successful negotiation of a maze of possibilities and choices is not an invention, and where the evidence shows that the inventor would have been directly led with an expectation of success to the whole claimed invention, it cannot be deemed not obvious. Innovation application tests relate to innovation patents and were introduced to legislation in 2001 with a seemingly lower threshold to be met. An innovative step exists when the invention is different from what is known before and the difference makes a substantial contribution to the working of the invention. In Jura's case, concerning patents for design of roadside posts for supporting signage, developed a 2-step process to determine whether the innovative step has been satisfied. To compare the invention as claimed in each claim with a prior art base and determine the differences, and to then look at those differences through the eyes of a person skilled in the relevant art in light of common general knowledge before the priority date, and ask whether the invention as claimed only varies in ways that make no substantial contribution to the working of the invention. The full court in Jura's case found substantial contribution to mean real or of substance. In considering a tangible example, a US company created a new type of wheels for manually operated wheelchairs, where the operator pulls back on the wheels to move forward. This wheel won Best Innovation in the New York Venture Summit Life Sciences category, as it made a substantial contribution to how the wheels within a wheelchair operated. In summary, invention relates to new, inventive, and not obvious designs, a high threshold to determine, compared with innovative designs where only a significant contribution to the existing design is required. However, both provide for the same remedies. Thank you for watching today's tutorial. I hope that you've gained a better understanding of the differences between invention and innovation steps.